Last week, the Fourth Circuit Court of Appeal issued a very important decision on qualified immunity. Now, qualified immunity has been getting a lot of press lately because of the Black Lives Matter movement. And the reason is that qualified immunity protects police officers from civil liability for claims of excessive force or other types of police misconduct. And it's a very difficult immunity to overcome, as this case shows. So I'll give you the link to the case down below, or the citation, and I'll discuss it a little bit in this video. So in this case, a black man was walking down the street in West Virginia and wasn't walking on the sidewalk. And the police actually stopped him for that. At the end of this encounter, he would be dead. The police would shoot him 22 times while he was lying on the ground. Before that, he would be beaten, he would be tased, and he would be wrestled to the ground by the officers. Despite these facts, the district court found that the officers were entitled to qualified immunity. To understand this ruling, it's important to understand a little bit about how qualified immunity works. So it's a two-step test. The first step is whether there's a constitutional violation that had been committed by the police. Now, generally speaking, this is not the more difficult of the two prongs to overcome, because if there's no constitutional violation, then you're not going to have a case to start with, at least under Section 1983. The second prong of the test is where things get difficult. Under the second prong, the law has to be clearly established at the time of the incident. And what the Supreme Court has interpreted this to mean is that more or less there has to be some case or some other law out there that says at the time this event is taking place, the conduct was unlawful. And it has to be specific. So it can't simply be a case that says excessive force is unlawful. That's a given. But it has to be something that says excessive force of this particular type is unlawful. And the Supreme Court has really clamped down on this and said, we can't look at this in the abstract. This has to be very concrete. There has to be some law out there that explains to these officers that what they are doing is unlawful. And that's a very, very difficult standard to meet because there aren't that many cases out there describing specific incidents, and because there are millions of different ways excessive force could take place. You could tase somebody in the leg, you could tase them in the arm, you can hit them in the head, you could wrestle them to the ground first. They might have a weapon, they might not have a weapon, and so on. And what this results in is that the officers basically get a free bite at the apple, because it's pretty unlikely that there's going to be a case out there already that suggests what they're doing under these specific terms is unlawful. That's what makes qualified immunity so hard to get around. In this particular case, the Fourth Circuit reversed the district court's finding of qualified immunity on two grounds. First, it said that Mr. Jones, the individual who will end up dead in this case, was already secured at the time that the police shot him, and therefore the use of excessive force on him at that time was unwarranted. And they say it's clearly established in the law that the use of force on a suspect who is already totally in police custody is unacceptable and is a constitutional violation. The police officer response is that Mr. Jones actually managed to pull some kind of small knife out of his sleeve and attempted to attack one of the officers, and therefore he wasn't secure. And the court's response to this was, well, even if we give you that, and we're not necessarily going to give you that, but even if we do, at the time that he was shot, he was lying on the ground, he was gurgling, he was motionless. So the officer said, drop your weapon. He didn't respond because he was basically comatose, and then they opened fire on him. And again, the Fourth Circuit said it was clearly established at this time that you can't shoot a suspect who is incapacitated and basically non-responsive. That is clearly established in the law, and therefore there is no qualified immunity. At the end of the opinion, after reversing the district court's finding on qualified immunity, the Fourth Circuit added a statement which I think is worth probably reading in whole here, so I'll read it out to you. It says, Wayne Jones was killed just over 1 year before the Ferguson, Missouri shooting of Michael Brown would once again draw national scrutiny to police shootings of black people in the United States. 7 years later, we are asked to decide whether it was clearly established that 5 officers could not shoot a man 22 times as he lay motionless on the ground. Although we recognize that our police officers are often asked to make split-second decisions, we expect them to do so with respect for the dignity and worth of black lives. Before the ink dried on this opinion, the FBI opened an investigation into yet another death of a black man at the hands of the police, this time George Floyd in Minneapolis. This has to stop. To award qualified immunity at the summary judgment stage in this case, would signal absolute immunity for fear-based use of deadly force, which we cannot accept. The district court's grant of summary judgment on qualified immunity grounds is reversed, and the dismissal of that claim is hereby vacated. So that's a very strong statement, and it does show that public protests and other activities of that sort do reach the courts, and quickly. This certainly wasn't a case that was subject to that type of protest at the time, but now, because of the public attention that's being paid to it, the courts are starting to take a closer look at this. And although the U.S. Supreme Court has so far declined to take any further cases on qualified immunity, perhaps they will take a closer look at it again.